Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. In this video, we are going to discuss a case law on juvenility. A person was released from jail after 12 years of incarceration after finding that he was a juvenile at the time of offense. This finding was given by the Honorable Supreme Court of India. But he cannot get back those 12 years of jail. See, this relates to the case of combined AP. Makkella Nagaya versus State of AP in writ petition number 429 by 2022 dated 6/5/9/2023 of the Honorable Supreme Court of India, 3 judges bench. Honorable Justice B.R. Gawai, Pamdi Ghantam Srinasimha and Sanjay Kumar considered the report of Telangana High Court presently. Telangana High Court, and ultimately they have come to the conclusion that the detainee was a juvenile at the time of offense. So therefore, as per section 15, read with 16(1)(g) of the Juvenile Justice Act 2000, his term of punishment should be only 3 years, not more than 3 years. So released after 12 years, he was released. Now, coming to the factual matrix, the incident took place on 21/12/2005. 21/12/2005 in a village called Sattupalli in present Telangana state. 2005 it was in combined state. You may be knowing Sattupalli, the constituency of late very famous Chief Minister Sri Jalagam Vengal Rao. Right. So this man, his name is Makkella Nagaya. He was arraigned as an accused in crime number 228 by 2005, registered under section 302, read with 34 IPC of Sattupalli PS in a murder case. The case was registered against him. The charge sheet was filed. He was convicted. In the case, he was given life sentence by 3rd ADJ Khammam. 3rd ADJ Khammam, because Sattupalli is in Khammam district. Then the matter, he along with some others. Then he appealed to the High Court of Andhra Pradesh, which dismissed his petition. Later, he filed an appeal in the Supreme Court, which was also not allowed. It was dismissed. Now, in 2022, he found another point that his date of birth, as per his date of birth, he was a juvenile at the time of offense. So, he filed a petition under Article 32 of Indian Constitution, alleging that he was only juvenile at the time of so-called offense and he should be released. And he has provided evidence also. As per the evidence, that is school record, he studied in MPP school, Vesannapeta of Korkollu Mandal of Krishna district. During that time, his date of birth was mentioned as 2/5/1989. That means at the time of offense, that is 21/12/2005, he was 16 years and 7 months old. This has been verified. So, when the matter came to the notice of the Honorable Supreme Court of India, they have directed the state of the High Court of AP, which in turn directed the Session Judge Khammam to conduct an inquiry. Of course, prior to that, the Inspector of Police, Sattupalli, he visited Krishna district, he made inquiries and came to know that this boy was a juvenile at the time of which he submitted his report. That is one part. On the second part, Session Judge was also directed to conduct an inquiry, as a result of which he conducted the inquiry, he examined some witnesses, he also came to the conclusion that the boy was juvenile at the time of offense. So ultimately, Honorable Supreme Court of India, after 12 years of incarceration of the boy, released him on bail, stating that the punishment, the maximum punishment for a juvenile cannot exceed more than 3 years. So please remember. And how this can be taken up at this particular point of time. At the time of charge sheet or at the time of first trial itself, you should have raised it. But please remember, according to section 7A of the Juvenile Justice Act, the question of juvenility can be raised at any point of time. So therefore, he raised it and he was successful. So Honorable Supreme Court of India considered this and released him. Very good judgment. So particularly this will be available for the juveniles who are in between 17 and 18 years of age, and they can take advantage of this case. So please read the case law and enrich your legal knowledge. Thank you.